We've got some new attorney Tyrone Blackburn mess, and it crosses over with the use of AI and some sanctions, and a layer that we don't usually get to where the attorney in question here, Tyrone Blackburn, is failing to pay the court-ordered sanctions. So dotdotslashstar, the GOAT, found this. This is in a case, one of the cases against Diddy, filed by Liza Gardner. Let me get the name right. And let's see what happened. In a case against Sean Combs, Judge Gordon is unhappy with Tyrone Blackburn's explanations for why he's not paying his $6,000 in AI misuse sanctions. An order to show cause hearing is scheduled for Monday, with Tyrone Blackburn ordered to produce his financial records. So this was filed yesterday on May 7th. Plaintiff's counsel is ordered to show cause why the court should not hold counsel in contempt for the repeated failure to meet deadlines and comply with this court's direction. On November 25th, 2025, this court issued an order to show cause. It was the first order to show cause, requiring Tyrone Blackburn to explain why sanctions should not be issued due to his reliance on AI-generated case law and his failure to communicate in response to inquiries about the reliance on hallucinated case law. After a hearing on December 3rd, 2025, the court concluded that Mr. Blackburn's submission and oral explanation failed to justify his conduct, and issued an order for sanctions pursuant to Federal Rule of Civil Procedure 11. As part of those sanctions, Mr. Blackburn was sanctioned with a fine of $6,000 under Rule 11C to be payable to the registry of this court at a rate of $500 per month. So he had a payment plan, payable no later than the 10th of each month, with the first payment due on or about March 10th, 2026, and the final payment due on or about February 10th, 2027. However, Mr. Blackburn failed to timely deposit the first required payment by March 10th, 2026, as well as the required second deposit due by April 10th, 2026. So this is being filed before the third payment would be due. So far he's made zero of the two. Nor, and this is probably the worst part, nor did Mr. Blackburn notify the court of his inability to meet the deadline to pay. So he was just silent. Instead, at a status conference held on April 13th, 2026, which would be 3 days after the payment due date for the second payment, the court, through its own inquiry, discovered that Mr. Blackburn had failed to comply with the sanctions payment deadlines. Subsequently, on May 4th, after the court noted its displeasures at the April 13th conference as to Mr. Blackburn's failure to communicate, now we're all the way on May 4th and we're underscoring the last time we got together, like 3 weeks ago, I said the communication was disappointing. But after that, Mr. Blackburn emailed the court explaining that he called and attempted to make my first payment over the phone or online, but was informed that the online payment system is only set up for criminal matters. So he wrote them a check for $500 and mailed it to the clerk's office as they instructed. And that's in an email from Tyrone Blackburn to the court. Mr. Blackburn further elaborated that he had explained to Judge Gordon during our last call that he could not afford to pay the full $6,000, and he did not have the money to pay the $500 per month beginning in March. Mr. Blackburn also noted that if he was able to recover additional contingency fees in the near future, he will be able to pay the months of March, April, and June. So he's got to win something. He's got to get something. As the court explained in its prior order to show cause, counsel who appeared before this court are bound by the rules of professional conduct of the American Bar Association as revised by the New Jersey Supreme Court. Rule 1.3 of the New Jersey Rules, titled Diligence, requires that a lawyer shall act with reasonable diligence and promptness in representing a client. Further, Rule 3.3a1, titled Candor toward the Tribunal, provides that a lawyer shall not knowingly make a false statement of material, fact, or law to a tribunal. Similarly, District of New Jersey Local Rule Appendix R, Lawyers' Duties to Other Counsel, provides, we will in good faith adhere to all express promises and to agreements with other counsel, whether oral or in writing, and to all agreements implied by the circumstances or local customs. Lawyers' Duties to the Court also states, we will not knowingly misrepresent, mischaracterize, misquote, or miscite facts or authorities in any oral or written communication to the court. So then the order goes on. After repeated conference calls and discussions with plaintiff's counsel, that's Tyrone Blackburn, including adjudication of a prior order to show cause, the court remains concerned about Mr. Blackburn's inability to comply with court directives, meet deadlines, and communicate effectively in circumstances where compliance may not be possible. Given the failure of Mr. Blackburn to follow this court's directives in its existing sanctions order, as well as Mr. Blackburn's continued failure to engage in reasonable communication with the court and opposing counsel. It is therefore, we've got two things ordered here, that on May 11th, let's pay attention to that, that's coming up. At 10:15 a.m., plaintiff's counsel shall appear in person before this court in Newark, New Jersey, in courtroom 9. So he's got to go in person, not one of these virtual conferences, to show cause why this court should not hold him in contempt for violation of the sanctions order. And it's further ordered that Mr. Blackburn shall produce his financial records. So they want his bank statements. They want copies of banking documentation for his professional accounts to demonstrate his ability, or lack thereof, to pay the monetary sanction in accordance with the terms and conditions set forth in the sanctions order. Signed, Leo M. Gordon, the judge. So that's the sanctions order. Now, dotdotslashstar went and looked at the transcript for the December 3rd order to show cause hearing about the AI misuse, leading with this one part here where the court is telling Tyrone Blackburn, take 10, Mr. Blackburn, breathe in through your nose, out through your mouth, close your eyes, try to reduce the stress. And again, you've heard me say it before. There was January 9th of this year in the Joseph Cartagena Fat Joe case. There was a virtual conference, and Tyrone Blackburn was yelling in response to the judge, "This is not a game. This is not a game to me." And reminding me, quite frankly, of how he sounded in some of these deposition clips that we've been able to see. So this, to me, seems like maybe that's happening here as well. And I will drop a link to dotdotslashstar's X account, this post specifically, in the description of this video so you can check it out. We'll take a look at it when we do our next live get-together about some of the Tyrone Blackburn mess. And one other short thing, this is going to be a separate case, but it's another plaintiff. It's Kirk Burroughs that Tyrone Blackburn is representing against Sean Combs, or Diddy. And there was a little bit of activity in this case that I thought was interesting, but also unsurprising. And so if we go to April 24th, there was an order from the court. It says terminating a letter motion for extension of time to file. This court will consider plaintiff's untimely opposition in ruling on defense's motion to dismiss. So plaintiff, who's represented by Tyrone Blackburn, was late in filing an opposition. The parties are on notice that failure to comply with the court's orders and all applicable procedural rules may result in sanctions, including monetary sanctions on counsel and the parties themselves, preclusion of the claims, defenses, evidence, and motion practice, and the case terminating sanctions of dismissal for failure to prosecute and default judgment. Plaintiff personally is on notice, so this is to Kirk Burroughs, that he is ultimately responsible for prosecuting his case, which may be dismissed or otherwise adversely affected because of his chosen counsel's failure to prosecute or failure to comply with court orders and applicable rules. And plaintiff's counsel, Tyrone Blackburn, shall inform his client of this warning. Ordered by Judge Mary K. Viscasil. And the same day, attorneys for Combs sent in this letter to the judge. Hey, we're the attorneys for Diddy in the above referenced action. We respectfully request clarification of the court's April 24th order, in which the court accepted plaintiff's untimely opposition to Mr. Combs' motion to dismiss the complaint. That opposition was filed on December 25th, 2025, as an exhibit to attorney Tyrone Blackburn's letter, requesting leave to file plaintiff's opposition to defendant's Rule 12b-6 motion beyond the court-ordered time limit. The April 24th order does not address whether Mr. Combs may file a reply to the opposition, and he desires to do so, so they do want to file a reply. Accordingly, we request clarification of whether a reply is permitted, and 2, when the applicable deadline is for the submission of the reply. If the default schedule order under Local Rule 61b applies, Mr. Combs respectfully requests an extension of time to file his reply from Friday, May 1st, 2026 to Friday, May 8th, 2026. This is Mr. Combs' first request for such extension. Now, why do we have to write this letter? This is why I was interested in reading this. Why do we need to write this letter? Because the parties can typically just go and stipulate, and then they say, hey, we've stipulated to a request. Can you just sign off on it? But what happened here? After reviewing the April 24th order, we attempted to contact Mr. Blackburn to obtain his consent for an extension, as is required under Rule 2G of the court's individual rules of practice. But his one-word response was no, without explanation. Finally, plaintiff's opposition does not comply with Rule 4A2 of the individual rules. It exceeds the 25-page limit by 11 pages and is not double-spaced, but instead spaced at approximately 1.5 lines, effectively expanding its non-compliant length even more. We therefore respectfully request clarification whether the court will consider the entirety of the opposition, and, if so, whether the court will permit Mr. Combs a corresponding enlargement of the reply page limit as may be necessary. We thank the court in advance for its consideration of the above. Respectfully submitted, Jonathan D. Davis. And the judge said, in light of the court's decision to consider plaintiff's untimely opposition brief, which also does not comply with the court's individual rules with respect to the length and spacing of memoranda of law, defendant is, of course, entitled to file a reply brief. So they give him the extension to the 8th as they asked. They also grant the enlargement of the page limit. And then we have this repeat. The parties are on notice that failure to comply with the court orders. Time limits, timely filing, communicating with counsel to see if you can consent to extensions. Failure to follow these rules may result in sanctions, including monetary sanctions on counsel and the parties themselves, preclusion of the claims, all of those things. Plaintiff is on notice. So now we're specifically calling out Burroughs that he's on notice that he's ultimately responsible for prosecuting this case, which may be dismissed or otherwise adversely impacted by his chosen counsel's conduct. And then we get all the same language, that the court directs the plaintiff's counsel to inform his client of this warning. And let's look at it on paper, because we're bolding it this time for emphasis. All of this reminder, right? We have to bold it. Why do we have to bold it? Because we just said this 3 days ago, and we're already having another issue. So we're bolding the same warning that we just gave you. And then we have this line added, the court also admonishes plaintiff's counsel to exercise more reasonable professional judgment in his dealings with defense counsel. So that's Mary Kay V there. That's a little bit of a Tyrone Blackburn update. And we're going to get together at some point and do a live stream and catch up on some other Tyrone Blackburn sort of Fat Joe, but also other cases that aren't Fat Joe, but they're all starting to cite each other. All of these defense attorneys are starting to loop in like, hey, this is what's going on. Another court's telling him to do this, and he's not doing it either. And on May 18th, we have an in-person sanctions hearing in the Fat Joe versus Terrence Dixon Tyrone Blackburn case. So some updates there, some movement in that case is right around the corner as well. So hopefully we get together for a live soon. Hope you guys are doing well. Let me know your thoughts and have a good one.